Welcome to the second part of the Data Protection and Privacy webinar. My name is Maxwell Okello. I'm the Chief Executive of the American Chamber of Commerce here in Kenya. I want to please ask my fellow panelists to turn on their videos so that we can begin. Great, there we are. All right, thank you all once again for joining us this morning, and especially to those who are joining us for the second time for this very insightful webinar. We noted the immense interest from last week's webinar or last week's session and the several requests that we got for information. We listened, and here we are this morning to continue with this critical conversation, and we're glad to see such a great turnout again today. So as per the norm, we will try and keep this within an hour. Your audio and video will be muted during the session or turned off during the session. We'll start off with a panel discussion that I will moderate, after which we will open it up to a Q&A with the audience. If you have any questions, please type them in the Q&A tab at the bottom of your Zoom window. I may call on some of you to address your questions or field your questions directly to the panelists. Now, last week's webinar gave us a very good high-level view of the Act, aspects relating to individual rights with respect to the collection, use, access to, and disclosure, and storage and security of personal information, as well as obligations for businesses to protect personal data of their customers, employees, and other persons they deal with. So where do we go from here? I think that's the million-dollar question that everybody is asking. And today's forum will seek to address the practical aspects surrounding the implementation and the compliance with the Act. And some of the themes or some of the big buckets that we want to address this morning, explore this morning, include the role of the Data Protection Commissioner, who's really the regulator in this regard, the role of the Data Protection Officer in an organization, the role of technology in data protection and privacy risk management, that is privacy by design and default. We'll also look at some of the practical steps that businesses can take in developing a data protection and privacy program. And as well, we will seek to cover some of the questions that you raised last week, including the questions that will come up during this particular forum. So to do that, to help us unpack that, to help us deep dive into this conversation, we have with us once again a very esteemed panel. We have the Senior Vice President, Compliance Risk Management Head at CT East Africa, Yvonne Jerry Motore. We have with us Commercial Attorney, Emerging Markets for Microsoft, Otilia Firi. We also have with us today, once more, representing the Principal Secretary, State Department for ICT and Innovation, who's also the CEO of the National Communications Secretariat, Engineer Dalian Obam, and Joseph Gidaiga, who's the Director and Head of Regulatory Compliance and Advisory at PwC. So welcome, panelists, and welcome everybody. So let's get into it. Let's dive right into it. And I want to start off with Engineer Obam. I'll address the first question to you. Last time you gave us a very good overview of the process that has been taken from a policy development perspective. You also gave us a sense of process in terms of where we are at with the recruitment of the DPC. And I want us this time to just delve a little more into the role of the Data Protection Commissioner, the regulator, the person we keep referring to as the DPC. And perhaps give us your sense or your view of some of the practical considerations that the DPC will need to deal with once they are in office and actually start delivery or implementation of the Act. Over to you, Engineer.
Thank you very much, Maxwell. Good morning, everyone. I'm glad to be here to represent my boss, who is the PS. I think that the statutory roles are very clearly captured in the Act, the role of the Data Protection Commissioner, and throughout the Act, we see what the functions are, what the powers of the Data Protection Commissioner are, the regulation of data controllers and processors, developing codes, suspending, if need be, transfer of data outside the country, and prescribing, in certain instances, compliance with certain provisions of the Act. And so today I would like to talk about maybe some of the things that are not prescribed in the law that the Data Protection Commissioner will be expected to undertake. Once the recruitment takes place, structurally, the DPC the office is going to be a state agency under the State Department of ICT and Innovation in our ministry, which is also responsible for ICT, Innovation, and Youth Affairs. So we have got 3 PSS, ICT and Innovation, Broadcasting and Telecommunications, and the Youth Affairs. So this office will be reporting to the PS for ICT and Innovation. Currently is Mr. Jerome Ochieng. So again, as Maxwell has said, shortlisting is going on. Because of COVID-19, the Public Service Commission is saying they are focusing on recruiting nurses to deal with the situation, and the next item after that will be the actual recruitment of the DPC. So we expect that the new financial year, which starts on 1st of July, we should have the office in place. And then, so once the office is in place, we expect that they'll have to look for premises. The individual hired will look for offices, will serve to develop operational documents not related to the Act. For example, HR manuals, financial procedures, recruitment of key staff, determining the organizational structure of the the commission itself. For example, communication, legal, technical, and for the enforcement of the Act, look at the jobs and determine which departments are needed. Looking at other jurisdictions, you may have an office that maybe deals with the issues that are local nationally, and maybe have a different department that deals with the issues that are international in nature. Again, just proposition from me. Then capacity building of this staff, because Kenya is the first time we are doing this. So we'll have to do some capacity building on the staff that will be recruited so that they are familiar with what is required of them. And I would expect that there'll be a lot of benchmarking with the already established jurisdictions on this. Look at technology. I think one of my colleagues will be talking about the role of technology in implementing the Act. So the commissioner will have to determine which technologies need to be put in place so that the work can be done easily. If you look at the EU, despite the fact that the GDPR, General Data Protection Regulations, came into force, if you read, you find that not all countries actually were compliant by the date that was set. Many, even up to today, are still struggling with meeting all the requirements. But I think the idea here is a journey that we've started, and we expect that we'll also go through the same process. In any case, the GDPR did replace the Data Protection Directive, I think of 1995, and even that had replaced a previous directive. So this is going to be a long haul. It's not going to be immediate. And then the more important thing is actually engagement with stakeholders like yourselves. So we expect that the Data Protection Commissioner will have to, even before starting enforcement, engage with the stakeholders to just get feel, and I think these kind of discussions that we're having now are a good starting place so that we can start developing certain feedback that we can give to the DPC, so that when they engage with us, we will be able to give them some directions on what they'll do. So the DPC will act as a registrar, as an oversight authority, as an enforcement agency. We'll carry out research, complaints handling, investigations. I think all these are covered in the Act. In terms of, for example, developing regulations, looking at some of our regulatory bodies today, what normally happens is that the regulations are drafted by the regulator, and then they go through a stakeholder consultation. So the Data Protection Commissioner will have to engage with stakeholders when they are developing regulations or even guidelines before they are, they become enforceable. So that's a very important role that the DPC will undertake, to engage with you and other stakeholders to make sure that they get the feel of what is expected of them. And this stakeholder engagement will be really important. Lastly, I think they'll have to carry out public communication as awareness, engaging with different stakeholders. And I would expect that, for example, the engagement with the banking industry probably will be different from engaging the tech community. So each of these different sectors of the economy will have to have a specific engagement with the Data Protection Commissioner to ensure that they are aware of what is expected of them. Let me just say that our expectation as a ministry is that this law is not just about protecting personal information, but we expect that the industry will use this personal data and derive economic value. And also, as we try to transform our economy to become a digital economy, data will be used as an economic, fuel to move our economy to the next level. So perhaps, Mr. Chairman, I can leave it at that. And if there are any additional questions, I will be able to attempt to answer them. Thank you very much.
Okay, thank you. Thank you very much, Engineer Obama. I'm already seeing an interesting perspective here already from one of the participants. They're of the contention that, if the ministry is sort of the one who's going to be housing this and potentially, being able to drive, so to speak, the office of the DPC. Isn't there some conflict, given that the government actually probably poses the biggest risk in terms of privacy when it comes to data? What is your view on that?
Well, I think the law applies both to private companies as well as to public institutions. Mm-hmm. And the way the law, this office has been structured, it's actually an independent office, and we have many such examples. For example, we have the Ombudsman, the Commission on Administrative Justice, that's currently administering the law on access to information. And that applies to all institutions. So I don't see a conflict. You see, as government, we have a role of running the country. So, so all public institutions have to be answerable to a ministry in the government. Yeah. And I think the individual or the individuals that will be running this commission will have to carry out the responsibilities according to the law. And knowing the law is there, okay, there are exemptions, yes, but those exemptions are not targeted at any particular ministry. I think those are clearly stated what should be subject to exemptions. So if the individuals who are running this commission, and especially the data commissioner, do their job, they should be able even to dock our own ministry should they run afoul of the provisions of the law. That's what I would say. And I think we have many institutions that are independent, but actually they are established by government itself, and they do carry out their rules. Look at the courts, look at the Kenya Revenue Authority, look at other institutions that do actually carry out their mandate, and none of the government public institutions are exempt just because they are, they're government institutions. That's what I would say.
All right, fantastic. Thank you for that, Engineer Bam. Let me bring in Yvonne into this conversation. And Yvonne, the question for you is, what is the role of a data protection officer, or DPO, in an organization? I know City is really, steps ahead in terms of putting in place this office. So could you please speak to that, and perhaps also address the aspect of the governance, risk and management compliance officer, whether or not that and the DPO roles can be carried out by the same person. Over to you.
Yes, certainly. Happy to take that. And good morning, everyone. Thank you, Maxwell, for the invitation to continue this conversation in this forum. So as I was listening to Engineer Bam, the themes are very similar between the role of the DPC and actually the role of a data protection officer, or the DPO. And maybe as we try and figure out what this JD actually looks like, we can take some clues from what's within the Act as a first step. So first of all, both public and private bodies do need to consider, based on their operations, whether to appoint a DPO. I think certainly from a financial services perspective, it goes without saying that you would need to appoint a DPO. And the Act does specifically say that you could be a staff member of the organization as a DPO, and that role could be filled by somebody who's already in another capacity. So, but there is a clear expectation that there's no conflict of interest between the two functions, right? So to address that question from the previous session, can a governance, risk and compliance practitioner also function as a DPO? I would say yes, and certainly that as things stand right now from a City Kenya perspective, that's what we're doing. So it also is possible that you could have a single DPO who's responsible for a group of companies. That structure is also permissible. There was reference to the fact last time that we do not necessarily have explicit professional qualifications that are required at this moment. I think probably as things develop, that might come to fruition, because there is in the Act, specific reference to the fact that you should have some relevant professional experience if you're going to take on this role. But I think, one of the big clues in terms of determining how you're going to design this role is that you actually do have to name the person on your website with contact information, and the commissioner also needs to be aware as to who this person is. So for all intents and purposes, this is a regulatory role, and I think that kind of points to the direction that needs to be somebody with relative seniority, within an organization. And I'll talk a little bit more about why I feel that is the case. So there are in the Act some kind of explicit elements of this job that are there. So one of them is that it's clearly an advisory role. So you need to be able to advise the business with regards to the obligations that they have, relative to the Act. This famous data protection impact assessment, which we touched on last session as well, which is basically the tool where you can risk assess your exposure relative to data processing. That tool is actually a very critical way for the organization to have visibility over where they may have need for additional enhancements in their processes. And the DPO has to be, kind of intimately involved in advising around how that tool should be developed and considered, who would participate in making some of the assessments therein. There is kind of a broad statement, and I think this is maybe the area that hopefully once the regulations are in place, we can get a little bit more color on. There's reference to the fact that the DPO is required to ensure compliance to the Act. And I think City would not be unique in taking the position that ensuring compliance can never be one person's responsibility within an organization. So there's, in a lot of respects, I think what that is saying is that the DPO has an oversight responsibility. But in terms of the doing and ensuring compliance, Citi's position is certainly that really belongs, in all the businesses and all the functions within an organization. So the example here would be, to consider that as much as you have a DPO who's providing oversight, that you also have in-business privacy officers who are then doing, detailed monitoring and assurance activities as well. So, and then one of the other aspects here is with regards to building capacity and training. Of course, as a DPO, you cannot build capacity and train unless you yourself have, the requisite knowledge. And so I think, organizations do, I think early on need to determine who the DPO is and direct the appropriate resources so that we can start upskilling, these individuals to, basically start to understand this whole new world of privacy and protection. Speaking personally, it has been a kind of a journey in terms of self-education in a lot of respects, right? So, certain concepts that might be familiar to lawyers may not be as familiar to non-lawyers who still have to be able to, train the organization and employees about data protection. So things like, legal basis, things like pseudonymization. I actually said that word one time without saying it. But the point is that this is literally a whole new world, right? So we do need to think about how we upskill ourselves just as much as Engineer Obama has said that there's that capacity building that needs to happen at a government level. It certainly needs to happen as well from a private sector perspective. So high level, I think maybe I'll stop there, Maxwell. That's a basic JD or basic indication as to what a DPO role looks like. And maybe I'll just add one other thing, which is with regards to the fact that there's the current state. So as much as the country is starting to understand, what the Act actually is telling us, at some point we will get to the point where this is now BAU. So I think the role of a DPO today and the role of a DPO once, it becomes, a BAU construct within an organization, it's going to look quite different. Right now, a lot of the effort is around, creating training materials. We as a DPO, obviously, you would not want to disseminate 100 pages of training, to staff. And certainly you would want to be leading the conversation with the board and with senior management in an interactive way. So you're not, you don't want to take the lazy route and saying, okay, yes, we have a new act and this is, read the act and kind of try and understand this. At Citi, we have been, we spent a lot of man hours as a steering committee, and creating that steering committee is an important step as well, because tone from the top is very important, and trying to determine who is going to lead that conversation in the organization. Certainly the CEO, certainly head of legal, head of compliance, head of technology, head of operations, head of HR. For those who have InfoSec or cybersecurity officers as well, those should be part of the early conversation in driving the direction on privacy. And ultimately, the DPO needs to lead that conversation and make sure it's staying on track.
All right. Thank you very much for that, Yvonne. And perhaps a quick follow-on question for that would just be, how has this been, how has the DPO office been actualized in, some of the European or American, operations? Are there some parallels that we can draw and learn from?
Yeah, I think there are a lot of parallels that we can draw, because I think in a lot of respects, as much as we don't have regulations in place, there is a lot of mirroring between the GDPR and our particular act. I think for those organizations that maybe have the benefit of having already to comply with GDPR, you would maybe, it might be a little bit easier because you probably would already have a policy framework in place that you would obviously need to localize and ensure that you're able to include any additional requirements that are here within our particular jurisdiction. But there are experiences that we have observed. For instance, how would you go about creating a privacy statement? Because data protection is very much about transparency as well. You need to be transparent outwardly, to the public and to your customers about how you're handling their data. So that outward communication is important. I think in a lot of institutions outside of Kenya, this has already been thought out quite well. So there's no necessity to kind of recreate the wheel from that perspective. So then there are a lot of resources also in public domain that we can tap into at this early stage and trying to figure out how to fulfill some of those requirements as well.
Okay, great, thank you. I want to bring in Ottilia, but before I ask the question, I just want to remind the audience, please post your questions in the Q&A tab, not the chat, the Q&A tab, so that it's easier for us to track it. So please just remember that Q&A tab, not the chat tab. So Ottilia, what is the role of technology in this whole process? How does technology help with the design of data protection and privacy risk management within the organizations?
So one of the provisions of the Act, it speaks to organizations putting in place adequate safeguards to protect personal data, based on, of course, all the principles that Joseph Akredi shared last week. And this is the place where technology comes to play. And it's the place also where privacy meets security. It's how we like to think about it, at least as a company. From a privacy by design and privacy by default, I thought it might be worthwhile to explain what those terms mean, just to level set. So the idea of privacy by design and or by default is actually not a new or additional burden to companies. I actually think it's probably one of the first things, as in one of the few things that helps give some guidance on the strategy that organizations can take with regards to implementation. So it's kind of giving you a suggestion. You have to comply with these things, and these are two mechanisms that you could actually use to achieve that. The one is ensuring that you, by design, you at the beginning of any process or when you're evaluating putting out a new product or service, think about what your privacy strategy is going to be for that product and or that service, and build into your process controls that can help you achieve compliance. By default, think making sure that if you recall some of the principles discussed last week around lawfulness, adequacy, retention, transparency on how you use data, ensuring that your products or services have those controls and or features by default offered to customers. A good example that I've seen shared quite often with regards to the by default is when you think of from a Microsoft perspective, most of you are probably familiar with our Office, our productivity suite, right? Office, where you have the Outlook, email, and other tools. Imagine what that requires for us is that we should ensure that our features by default within, as in the default settings within our product, are such that we're using very little personal data, if at all required. That we have controls around who can access that data and or how that data is shared, that we're transparent so that the data subject or the person who's interacting, perhaps with our email service, is able to see exactly what that data is used for, where it sits, who might have access to it, et cetera, et cetera. So that's the idea of data privacy by design and by default. From a technology perspective, the way that we see technology being able to help companies is, in one way, is to help you automate that process. I started to speak last week a bit about how when we went through the process of re-engineering our products and services in preparation for GDPR compliance, we created controls and features and even new products. We actually have a product called Compliance Manager that's available across all our products and services that actually helps you with your information protection compliance journey. And this is all the way from helping you classify or understand where your data sits, to set policies and controls around who can access that data, what that data is used for you to track what the processing activities look like within your organization, and to support you to be able to report or to show that you are complying in the event that Data Protection Commissioner comes knocking on your door. So that's really where I see the role of technology in supporting organizations.
All right, fantastic. Thanks, Otilia. Let me bring in Joe into this. And Joe, the key question is, what are some of the key steps, practical steps that businesses can take to develop a data protection and privacy program?
Thank you, Maxwell, and good morning, everyone. Glad to be here again, as mentioned from last week's presentation. Perhaps one way to sort of respond to that question, Maxwell, is firstly considering, what should an optimal framework for protecting privacy look like? And to my mind, there's about 8 key features that one should consider as part of their data privacy and protection framework. At the top of it is, and the first rule is, whatever program you're going to put in place, the processes you put in place to manage this privacy risk are, to some large extent, dictated by your strategy as a business. Because your strategy as a business determines, for example, who are your customers? Are they largely individuals, or are they largely legal entities? So the more individuals that form part of your customer base, the greater the risk this might, the privacy risks associated with your business activities. Is your part of your organizational strategy to do business across borders? And to the extent that you're doing business across borders, are you having to share your customer information across borders? Or are your customers actually based in places like Europe, in which case there's a potential risk to you that you'll be caught by GDPR? So once you understand what your organizational strategy is, it's then easy to sort of see where the privacy risk issues will arise from. Associated with that then is the idea of governance. So to put a program in place, it must have endorsements from the very top, your board and your management. So your board has to prioritize that as a risk issue and mandate that a policy framework is put in place and approve whatever that policy framework, and approve the policy framework. And then management's role is really to drive the implementation of that policy framework and program within the organization. And then to obviously buttress that, then you need, to also ensure that your staff are fully trained around the features of the privacy program, why it's important, what the law requires. Secondly, you need to have in place the relevant documentation that communicates what your privacy strategy is. And by this, I mean privacy notices, which are external facing. They're the documents you give to your clients, to external vendors that you work with, and other individuals that you interact with from a business point of view, where essentially you're telling them the sort of data that you collect from them, the information that you collect from them, and the purposes for which you use that information, how you secure that information, who you share it with. Basically, your entire privacy strategy should be summarized in this privacy notice that's external facing. Then you need a policy that's internal facing. It's really geared at your employees and your contractors, so that they understand where how you go about protecting personal data as an organization. So, and what their roles and responsibilities are in the context of that exercise. You then also need to think about how information is collected and comes into the organization and the way it flows through the organization. This is what we call data lifecycle management. So essentially, it's identifying the personal data that you hold identifying where it is held so that you have a clear idea of the inventory of data that you're holding and the sort of risks that that data would then pose for you. Ensuring that that information is accurate. So if you remember the principle that we talked about in the first session, it's that awareness around, if we have this data, is it accurate? Do we have a way of verifying on an ongoing basis that it's been updated? And then, incorporating also some of these features of privacy by design and default that Otilia talked about. And also, whenever you want to apply, say, a new technology or apply a new purpose to that data, perhaps you might need to consider whether to do a privacy impact assessment. So that's about how you deal with the information when it comes into the organization. Fourthly, you need to then think about how you manage your data that you give access, that you give third parties access to. So these are those service providers we talked about last week, who you would call processors, because as an organization, you need them to perform certain activities and provide these services in relation to that information that you hold. So whilst you can do everything within your organization to protect it, the risk could actually come through these third parties if they themselves have not put into place adequate safeguards to protect the information once you give them access to it. So around this, you need to then think about how you do your due diligence on these third service providers, especially around the sort of safeguards they have in place. You have to enter into a contract. The law actually requires you to enter into contracts with such parties in which you're going to embed some of these risk management practices, and perhaps also seek some indemnifications if the breach happens on the through the data processor. And if the data processor is also based outside of the country, then you have to think about, are there adequate safeguards in that country that the processor operates from, and can you get that sort of assurance? Then in the context of your own controls, you have to, the issue around data security is very important. Again, Otilia touched on that. And so the question there really is, what sort of security controls do you have in place in terms of encryption, in terms of pseudonymization, anonymization? So all those technologies that were being alluded to by Otilia, what is the scale of those that you have in your organization? Should you be investing in new technologies that help to embed those data security features? Depending on the sort of organizations you're working for, it may be that you're already required to have a robust cybersecurity program in place. And so it's really extending that to ensure that it also adequately covers personal data. From another perspective, you need to think about, in the event of a breach, are you well positioned? And what are the processes that you have in place to manage breach incidents? That ability to be able to notify the regulator within 72 hours. Right now, do your current processes enable you to gather that information about the breach within that time frame and report it? Another key consideration is around data subject rights and processing. Again, we talked about those data rights at length in the last presentation. And so the key question here is, does your data privacy program facilitate the protection of those rights, in the sense that if data subjects make requests of you to give them access to the information because they have a right to do that, then are you able to comply with that request? To the extent the data subject might ask you, for example, to delete the information or otherwise not process it. Again, are you in a position to comply? If you, on the other hand, legitimately have legitimate interest in holding on to that information or continuing to process it, are you able to establish those lawful purposes, lawful basis for processing information? So again, it's really that process of thinking through those rights that have been set out under the legislation and seeing your ability to respond to those rights and to uphold those rights, even as you apply your own, even as you use the information for your own legitimate interests. And then lastly is just the issue around risk management. Once that program is in place, you have to find a way of ongoing monitoring of new risks that might
Okay, fantastic. Thank you very
Yeah.
much, Joe. I want to bring the audience into the conversation. And there's a question here from Anthony Mudui. I think, Anthony, you can actually ask your question directly to the panelists. Eva, can we unmute Anthony? Anthony, please go ahead. Anthony Mudui? All right, I'll ask the question on his behalf. So Anthony is asking, the office of DPC sounds like a very powerful office within the seemingly sweeping powers over data protection and privacy. What oversights the office of the DPC? Engineer Bam, you want to take this?
Thank you. Hi, Anthony. Actually, I'd typed an answer to Anthony.
Okay.
And I was looking at the law under Section 70 requires that the commissioner actually, among the reports that they send annually, is a report through the cabinet secretary to parliament. Because remember, the appointment of the commissioner is by the president, but through vetting by parliament, by the National Assembly. So the DPC is required to send annual reports to parliament through the minister. And the report, according to the law, contains information which the commissioner considers appropriate, the impact of the work they're doing, any impediments which they're facing with relation to meeting the objectives of the Act, and other information that they may consider necessary. So annually, the DPC is supposed to give reports to the National Assembly. So the oversight is the National Assembly, but of course also the Ministry of ICT, Innovation and Youth Affairs.
All right, okay, thank you.
Thanks, Engineer, thanks.
Gary Banton.
All right, I want to go to my namesake. You can see there's a Maxwell Max in the line. Maxwell, please go ahead and ask your question. Maxwell? Okay, I'll ask on his behalf. So Maxwell is asking, okay, first of all, he's thanking us for the clarification on the various roles, especially in relation to oversight. So he's from the health space, and he's asking how applicable and secure would the Act protect the access and storage of personal unique identifiers? Are there clear legal redress or procedures, penalties for breach of personal data? Who wants to take that? Joe? You want to give that a stab?
All right. Again, you recall from the last presentation that yes, there are sanctions that are embedded into the legislation and various fines, both through the courts as well as fines by the DPC. So through the court, data privacy breaches can attract fines of up to 3 million shillings and imprisonment terms of up to 10 years. Specific types of offenses, particularly failure to cooperate with the DPC or providing misleading information to the DPC, attract an even higher fine of up to 5 million shillings and also a potential imprisonment term. These are standard ways of expressing the penalties in our legislation. The DPC itself also has the ability to fine you up to 5 million shillings in relation to a breach of the Data Protection Act. And it's sort of the lower of 5 million shillings or 1% of your business turnover. So that sanctions regime is clearly embedded in the legislation. And I would imagine that because the DPC also has investigatory powers, if through the investigations they're able to determine that you are at fault for that breach, then the risk of the sanction then flows from those findings. And also remember that some of these things can come through because of data subjects themselves actually highlighting areas where the information has been misused or there's been unauthorized access and it's being used in a way that is detrimental to them. So they either go to the media, or alternatively could take legal action against you, or could make complaints to the Data Protection Commissioner. So I don't know if that fully answers your question, Maxwell, but suffice to say that there are sanctions under the Act.
Okay.
Maxwell, maybe I can add a little bit to that. And in just saying that, I think for the moment, and certainly in the GDPR construct, there's a lot of focus on the sanctioned part of it. But I think as time goes, and this is happening as well in the European jurisdictions, companies are being motivated to kind of take this emerging risk seriously. Also from the perspective of, whether it provides kind of additional operational efficiencies. And what I mean by that is, if you're holding data that is obsolete, you're not using it, and let's say it's inaccurate data, somehow you're spending resources in maintaining, that information. But if you have a way to be able to cleanse, or a tool that will, kind of help you cleanse your data, and make sure that you're using and keeping data only as necessary, then I think you could argue that there could be operational benefits, from doing that. And I think I don't know if that's where we're going as a country, but I know certainly in the European countries, if you're reaching out to, for instance, on government tender, you do have to demonstrate to some extent that you are complying with GDPR. So in this country where, a lot of, government business gets done, I guess you could conceivably say that if it's something that is taken on seriously, and if this area develops as well as it has in some of the European markets, you could conceivably say that, there is going to be questions brought to you about, before you engage in business relationships, can you show us, first of all, how it is that you're dealing with data privacy? And I think that threshold is going to start to climb, and I think organizations will start to get motivated differently, other than trying to avoid sanctions. There'll be other ways that we would need to consider the benefit of complying.
Thanks, Ibrahim.
Yes, Maxwell, may I add something to this? Early this year, the government published 2 regulations, civil registration regulations, and Huduma number regulations. And even in those regulations, if I recall, the exchange of information between public institutions is actually dependent on safeguards as put down in the law. So, limitation for what purpose, for how long, and the safeguards that have been put in place by the other government entity that is asking for this information, so that the security of that data is ensured. So I just thought I add this in, that even though there's the regulations are saying that government institutions that like civil registration agencies can exchange information, but they must do that within the law, the Data Protection Act, and the safeguards that have been put there. Thank you.
All right. Okay, thank you. Kerry Karimi, please go ahead and, Kerry Kirimi, please go ahead and ask your question.
Okay, sorry, sorry, I was a bit off. The question was now on the flip side of issues around access to information. How do you now relate that to data privacy in terms of, yes, I would wish to access certain public information. I'm making a request to a public institution to access information, for example, for my work or for my business. And on the other hand, will this public office, for example, claim issues of data protection? How do you make that balance? I know there are provisions in the law, there are provisions around how you balance certain exemptions and all that. So I just wished if you could touch on that. Thank you.
Okay. Thank you, Kerry. Wants to take a stab at that?
Okay, let me try. I'm struggling to see how you can go to an institution and ask for somebody's personal information. I think the access to information is information that should be publicly made available. And I think that's what the law under, I think, Article 35 of the Constitution, this meant to have information that previously we in government, stamped as confidential, is made available so that it can be used for research and all that. I think people's personal data does not fall within that category. And therefore, when you're asking for information, and if there is some personal information involved, that's why the issue of anonymization and pseudo-anonymization, that word, comes in, so that the people whose data or whose information is being asked for is you can use it, but in a way that doesn't identify the data subject. That's how I would start the discussion, and then maybe others can chip in.
Maybe I can just add to Engineer Obam's sentiments. And again, I think it's really about what's the information you're seeking to access. Is it information about yourself that government may hold? Because to that extent, if it's your own personal data that you're seeking and your own records from government, then the Data Protection Act does give you that right to request that information. You have a right to access the information that any organization holds. Again, it's important to note that all those rights aren't absolute, and that if there's another justifiable reason why that information can't be given to you or not given to you in the form you wanted, you may not always succeed with your requests for information about yourself. But as a matter of principle and by default, you have a right to access that information as long as it relates to you.
Thank you. We still have a couple of questions that we want to make sure that we touch on before we close. I want to ask Eunice, go ahead.
Hi, thank you, Maxwell. And my question is regarding due diligence. How often should due diligence on data processes and service providers be done? Thank you.
All right, due diligence on service, data service providers.
Maybe I can start off in taking that. I think certainly from a due diligence perspective, it needs to be something that is an ongoing exercise, right? So I think I mentioned the concept of a data privacy impact assessment. I think once an organization has kind of that risk picture in terms of where the exposure is, you would then obviously need to design your controls against that inherent risk. And make sure that, especially if third parties are kind of front and center and an important part of the way that you handle data, that the presumption there is that third party risk when it comes to data would be considered high risk, which means that the level of controls that you would need to have in place to offset that would need to be at an elevated level. So, so my personal sense is that, if you're considering high risk from a third party perspective, that due diligence needs to be ongoing. Certainly during onboarding, there needs to be a set of criteria that you would need to establish with regards to whether that third party has then the requisite controls, hopefully equivalent to what you have in your own organization, to be able to manage and mitigate the way that they are using your client's data. So at onboarding, it needs to obviously happen at a detailed level, and there needs to be a defined frequency, again depending on the risk appetite of the organization. At a minimum, I would say it should be something that is done on an annual basis. But I think you could argue that it should be more frequent than that, perhaps quarterly, again, depending on the kind of activity that is being undertaken.
Yeah, Maxwell, maybe I could come in and say that from Tony's previous question on oversight, and I did section 70 does say that the Data Protection Commission has to give annual reports to Parliament. I would expect that perhaps part of the guidelines that the Data Commissioner will be discussing with the stakeholders would be on how they report their compliance with the law. And I think that would form part of the due diligence. So the guideline may say maybe every year as a data controller processor, you may be required to just indicate how you've complied with the law, and that would require that, of course, you carry out your own due diligence internally and report that to the regulator. So I think that would require. I'm seeing this as probably an annual, at least annually, but it will depend on the guidelines that the commissioner will agree with the stakeholders.
Okay, thank you, Engineer Bam. Ottilia, you want to add something to that?
Yes, I wanted to speak for the service providers on the call. And I quite agree with what's been shared, both by Yvonne and Engineer Obam. Maybe one thing that I would just note is what the expectations of that due diligence would look like. It's understandable at onboarding to do a comprehensive due diligence to understand how personal data will be handled, processed, etc. To imagine frequencies of more than a year, as in if you try to do follow-up audits and or monitoring activities of more than an annual basis, imagine what sort of frustration that would cause for a service provider with multiple customers across multiple jurisdictions. So I do hope that there will be a balancing on the expectations of what that due diligence will look like, because otherwise we're all going to spend time auditing each other's processes around the protection, which could be frustrating. But yeah, that was just my comment from the service providers.
All right, from the service providers. And does this touch on, instances where you actually provided information yourself? So if you think about the, the credit reference bureaus and so on, is it the same sort of scenario that we're looking at?
Yeah, I mean, that's something that companies are going to, or organizations are going to have to enable somehow within their processes, because there's a very clear right for a data subject to be able to come and access their information and or to be able to ask for revisions and or to ask for it to be ported, as in to be sent across to another data processor. So I don't think there will be a workaround that. Yes, it could be a frustrating process, because you can imagine if you get a high frequency of requests of this nature and what that might cost for a company. Hence, we do think that leveraging technology to automate some of those processes is one way that you can maybe make that efficient. But yeah, there likely won't be a way around that requirement.
Great. I want to bring in, bring in Engineer Bam on this question that was sent earlier. It's basically asking about, so the question is this, the transfer of personal data outside of Kenya envisages a situation where before the data controller or processor transfers data outside of Kenya, proof should be given to the data commissioner that appropriate safeguard measures have been put in place with respect to the security and protection of that data, including the data that will be transferred to the jurisdictions with commensurate data protection laws, and that the transfer is actually necessary. And so the question is, just a sense of clarity around this, how this is likely to be implemented, and whether or not it will be feasible to do so for each data or data sets that are transferred from Kenya.
Wow, okay. If I were the data protection commissioner, what I would do is probably one of the guidelines or regulations would be to do with the transfer of data. Mm-hmm. And this would be done in consultation with the stakeholders so that we clearly define, and I think countries that operate in multi-jurisdictions like Microsoft, CT, PwC, would then maybe bring in experience from elsewhere, and we have a very clear set of rules on how data can be transferred. So once you have that in place, then I think it doesn't have to be on a case-by-case basis, but it's something that has been discussed and agreed upon. So I'm saying guidelines or regulations. When I was talking about the role of the data protection commissioner, I think one of the rules or regulations would be on transfer of personal information outside the country. And maybe when they are setting up their staff, they may have an office that deals specifically with this aspect. This is how I would look at it.
Okay, thank you, Engineer. Do you want to add to that?
Yeah. So under the GDPR, there's a concept of certifications, as well as where you're transferring data between related entities of a group. what you call binding corporate rules. And so you're able to either use the fact that you've been certified according to an international standard. So, you know, you've got ISO standards. I think that sort of set out what a robust data protection framework should look like. So to the extent that you've gone through a process that tries to meet the standards of those certifications, then it is one of the, that's one of the things that you could use to satisfy a regulator that, you know, you have adequate safeguards in place. So part of what you could ask the person to whom you're transferring data is, for example, do they adhere to some sort of ISO certification around the safeguards they put in place? To the extent that you're part of a group, have you developed internal rules? They call them binding corporate rules, talking about how it is you're going to share that information. So there are some practical measures, and I don't think we have enough time to really delve into that. But I think those two examples sort of give you a sense of, you know, how you could go about establishing that whoever you're sharing data outside of Kenya with has adequate safeguards, and what regulators would be prepared to recognize as evidence of such safeguards.
I want to take a couple more questions, if that's okay, as we wind down. Oscar Okwero. Oscar Okwero, please go ahead and ask your question if you're on the line.
Okay, my question was that the panelists, could you comment on the effect of COVID-19 on digital privacy rights? Because I did just a bit of research, and most of the contact tracing apps are a big threat to privacy. Of course, the data privacy regulations, most of them have a provision for, to override all the privacy rights based on either public good or maybe national security. But I just wanted you to comment on this, because I noticed most of this, in fact, most countries already have data privacy acts. So COVID pandemic notwithstanding, ideally what we're doing is against the very rules that we're trying to strengthen. So I just wanted a comment from the panelists, what they think of it and how it could be done in a better way, if there is any. Thank you.
Thanks, Oscar. Joe, you want to give that a start?
Yeah, I think it's important to understand, and I think I emphasized this during the presentation last week, that the rights you have as an individual are not absolute, the rights under the Act. There's always a balancing act, because there could be other obligations, rights and obligations that when weighed up, override, that right to data protection or right to privacy. So as you mentioned yourself, because COVID is a life-threatening disease that spreads very quickly, and it is important to be able to move with speed and share information so as to manage it, the government can very much rely on the fact, and organizations also, that the way they're processing data is essential for protecting either the vital interests of the data subject themselves or other people, other individuals, other data subjects. And also that public health justification, the public interest justification. So it's important to understand that the way that the Act is crafted and the way legislation in other places is crafted, it's always a balancing act. It's not intended to be absolute, that your right to privacy is absolute. No, it has to be weighed up against other important concerns, other important principles that themselves are also provided for under the Constitution. So that's the way I would seek to look at that. But you may need to then think of individual cases where you feel that maybe government has gone too far, organizations have gone too far. And at the end of the day, it's them as the controllers who have to be able to demonstrate that they had another alternative basis for processing the information to the extent that that conflicts with your individual right to privacy.
Okay, thank you very much.
I'll just add something small on that. And I think the other element here, because COVID-19 is obviously something that we're all living with, as organizations. So, some of the questions that may come up is if somebody in your organization is unwell, you know, to some extent, you could argue that other members of that team should be aware of the fact that they may have been exposed, you know, to that risk. So as an organization, though, you have to kind of strike that balance that Joe has spoken to in terms of being able to communicate information that is important to communicate, but consider that there are personal privacy considerations to put in place here. So the point about making the information anonymous, right? You can say that, you know, you can provide the information in a way that does not violate the privacy. There's some practical conversations that are happening in the still have to be careful about not revealing the personal information of an individual.
Thanks, Yvonne. Tilia, you wanted to add something to that?
It was actually in the same grain as Yvonne was just sharing, that while there may be a legitimate basis for the data that's being processed in contact tracing apps, you can balance that still with ensuring protection of the data. So that doesn't mean that the obligation to keep the data secure or to minimize the data for only what you need or to retain it only for as long as you need, that those things fall away. But yeah, I think Yvonne covered it well.
Okay. All right. I want to take one final question as we close. James Mbogwa, Eva, could you please unmute James Mbogwa? He's on the line.
Yes, thanks, Maxwell, and thank you for such a great panel. I hope we have one last session with them where we can actually ask them questions. But anyway, I just wanted to ask, are there provisions in the law for data purging? Like if I want to leave a particular organization or to no longer be a customer of a particular organization, that my information can be deleted or purged so that it is no longer held in custody by that particular organization? And are there provisions for even timelines for how soon that should be done?
Joe? Then Otilia.
So there's principles around only retaining data for as long as was required. That's on the one end. And then there's also a provision that speaks to portability of data. So when you leave one entity and you want to move to another entity, think of it when you're changing banks, when you're changing telco operator, they need to be able to facilitate for you to be able to move your data across. So it really depends on which of those you want to invoke, right? You can either rely on the requirement that a company should only retain data for as long as is necessary based on those principles, or ask them to delete it, which is a right that you would have if they no longer have any purpose for it. The only thing I would say as a caveat is that there may be some legal obligations that that entity has that may overwrite your ability to have them delete information immediately. Think, for example, banks who have an obligation to retain information for a period of, is it 7 years, according to central bank, for supervisory purposes for the central bank. So there may be technicalities around the immediacy with which that could be done. But those are the two, at least, that I would start off with. You do have options around, around that.
And again, just adding to Otilia's, the grounds mentioned by Otilia, also if the organization has, for example, if they are able to prove that, for example, they need to hold on to your information, for example, to defend a legal claim. And it could be that you're in dispute with the organization and they need the information they hold about you to either create a defense for themselves against the suit that you may have brought, or for that matter, any other party that brings a suit, and it is important for the organization to be able to retain information it holds about its data subjects to be able to defend that claim. So that's another additional ground where the organization could resist purging your information. But otherwise, by default, you do have a right to ask for information to be purged. But as Otilia mentioned, there could be overriding interests on the part of the controller.
All right, great. I think in fairness, you know, we've run out of time. It's been a wonderful discussion. I want to invite us to take a quick poll that should be coming up on your screen right now. There you are. 2 questions will take you all of 10 seconds to answer. But as we close, I think it is clear that this is an important topic and one that will remain topical for a while. And as guidelines are being developed and put in place, as this act is being rolled out, I think as industry, we do have a role to play in engaging and providing input to the DPC. And we as AmCham, I want to just assure everybody that we intend to keep this engagement alive and to channel the input of our members and those of our related stakeholders as this progresses. And so as we wind up, I want to just say a big thank you to our panelists who have been great. They've offered their time twice to come and talk to us. So I want to thank Otilia from Microsoft, Yvonne from Citi, Joe from PwC, and Engineer Obam from the National Communications Secretariat for coming and sharing their great insights and their wisdom with us. Big thank you all to everybody who has participated in today's webinar, and we look forward to hosting you again next time. So with that, I want to bring the webinar to an end and want to wish you all a wonderful day, and please do take care of yourself. Thank you.